Section 25 of Geneva Conventions, August 1949. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 3. Status and Treatment of Protected Persons. Section 4, Chapters 1 through 3. Section 4. Regulations for the Treatment of Internees. Chapter 1. General Provisions. Article 79. Cases of internment and applicable provisions. The parties to the conflict shall not intern protected persons except in accordance with the provisions of Articles 41, 42, 43, 68, and 78. Article 80. Civil capacity. Internees shall retain their full civil capacity and shall exercise such attendant rights as may be compatible with their status. Article 81. Maintenance. Parties to the conflict who intern protected persons shall be bound to provide free of charge for their maintenance and to grant them also the medical attention required by their state of health. No deduction from the allowances, salaries, or credits due to the internees shall be made for the repayment of these costs. The detaining power shall provide for the support of those dependent on the internees, if such dependents are without adequate means of support or are unable to earn a living. Article 82. Grouping of internees. The detaining power shall, as far as possible, accommodate the internees according to their nationality, language, and customs. Internees who are nationals of the same country shall not be separated merely because they have different languages. Throughout the duration of their internment, members of the same family, and in particular parents and children, shall be lodged together in the same place of internment, except when separation of a temporary nature is necessitated for reasons of employment or health, or for the purposes of enforcement of the provisions of Chapter 9 of the present section. Internees may request that their children who are left at liberty without parental care shall be interned with them. Wherever possible, interned members of the same family shall be housed in the same premises and given separate accommodation from other internees, together with the facilities for leading a proper family life. Chapter 2. Places of Internment. Article 83. Location of places of internment. Marking of camps. The detaining power shall not set up places of internment in areas particularly exposed to the dangers of war. The detaining power shall give the enemy powers, through the intermediary of the protecting powers, all useful information regarding the geographical location of places of internment. Whenever military considerations permit, internment camps shall be indicated by the letters I-C, placed so as to be clearly visible in the daytime from the air. The powers concerned may, however, agree upon any other system of marking. No place other than an internment camp shall be marked as such. Article 84. Separate internment. Internees shall be accommodated and administered separately from prisoners of war and from persons deprived of liberty for any other reason. Article 85. Accommodation, hygiene. The detaining power is bound to take all necessary and possible measures to ensure that protected persons shall, from the outset of their internment, be accommodated in buildings or quarters which afford every possible safeguard as regards hygiene and health, and provide efficient protection against the rigors of the climate and the effects of the war. In no case shall permanent places of internment be situated in unhealthy areas or in districts the climate of which is injurious to the internees. In all cases where the district in which a protected person is temporarily interned is in an unhealthy area or has a climate which is harmful to his health, he shall be removed to a more suitable place of internment as rapidly as circumstances permit. The premises shall be fully protected from dampness, adequately heated, and lighted, in particular between dusk and lights out. The sleeping quarters shall be sufficiently spacious and well ventilated, and the internees shall have suitable bedding and sufficient blankets, account being taken of the climate, and of the age, sex, and state of health of the internees. Internees shall have for their use, day and night, sanitary conveniences which conform to the rules of hygiene, and are constantly maintained in a state of cleanliness. They shall be provided with sufficient water and soap for their daily personal toilet, and for washing their personal laundry. Installations and facilities necessary for this purpose shall be granted to them. Showers or baths shall also be available. The necessary time shall be set aside for washing and for cleaning. Whenever it is necessary, as an exceptional and temporary measure, to accommodate women internees who are not members of a family unit in the same place of internment as men, the provision of separate sleeping quarters and sanitary conveniences for the use of such women internees shall be obligatory. Article 86. Premises for religious services. The detaining power shall place at the disposal of interned persons of whatever denomination premises suitable for the holding of their religious services. Article 87. Canteens. Canteens shall be installed in every place of internment except where other suitable facilities are available. Their purpose shall be to enable internees to make purchases at prices not higher than the local market prices of foodstuffs and articles of everyday use, including soap and tobacco, such as would increase their personal well-being and comfort. Profits made by canteens shall be credited to a welfare fund to be set up for each place of internment, and administered for the benefit of the internees attached to such place of internment. The internee committee provided for in Article 102 shall have the right to check the management of the canteen and of the said fund. When a place of internment is closed down, the balance of the welfare fund shall be transferred to a welfare fund of a place of internment for internees of the same nationality, or, if such a place does not exist, to a central welfare fund which shall be administered for the benefit of all internees remaining in the custody of the detaining power. In the case of a general release, the said profits shall be kept by the detaining power, subject to any agreement to the contrary between the powers concerned. Article 88. Air raid shelters, protective measures. In all places of internment exposed to air raids and other hazards of war, shelters adequate in number and structure to ensure the necessary protection shall be installed. In case of alarms, the internees shall be free to enter such shelters as quickly as possible, excepting those who remain for the protection of their quarters against the aforesaid hazards. Any protective measures taken in favor of the population shall also apply to them. All due precautions must be taken in places of internment against the danger of fire. Chapter 3. Food and Clothing. Article 89. Food. Daily food rations for internees shall be sufficient in quantity, quality, and variety to keep internees in a good state of health, and to prevent the development of nutritional deficiencies. Account shall also be taken of the customary diet of the internees. Internees shall also be given the means by which they can prepare for themselves any additional food in their possession. Sufficient drinking water shall be supplied to internees. The use of tobacco shall be permitted. Internees who work shall receive additional rations in proportion to the kind of labor which they perform. Expectant and nursing mothers and children under 15 years of age shall be given additional food in proportion to their physiological needs. Article 90. Clothing. When taken into custody, internees shall be given all facilities to provide themselves with the necessary clothing, footwear, and change of underwear, and later on to procure further supplies if required. Should any internees not have sufficient clothing, account being taken of the climate, and be unable to procure any, it shall be provided free of charge to them by the detaining power. The clothing supplied by the detaining power to internees and the outward markings placed on their own clothes shall not be ignominious nor expose them to ridicule. Workers shall receive suitable working outfits, including protective clothing whenever the nature of their work so requires. End of Section 25. Recording by Maria Kasper. Section 26 of Geneva Conventions, August 1949. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 3. Status and Treatment of Protected Persons, Section 4, Chapters 4 through 8. Chapter 4. Hygiene and Medical Attention. Article 91. Medical Attention. Every place of internment shall have an adequate infirmary under the direction of a qualified doctor, where internees may have the attention they require, as well as an appropriate diet. Isolation wards shall be set aside for cases of contagious or mental diseases. Maternity cases and internees suffering from serious diseases or whose condition requires special treatment, a surgical operation or hospital care, must be admitted to any institution where adequate treatment can be given, and shall receive care not inferior to that provided for the general population. Internees shall, for preference, have the attention of medical personnel of their own nationality. Internees may not be prevented from presenting themselves to the medical authorities for examination. The medical authorities of the detaining power shall, upon request, issue to every internee who has undergone treatment an official certificate showing the nature of his illness or injury and the duration and nature of the treatment given. A duplicate of this certificate shall be forwarded to the central agency provided for in Article 140. Treatment, including the provision of any apparatus necessary for the maintenance of internees in good health, particularly dentures or other artificial appliances and spectacles, shall be free of charge to the internee. Article 92. Medical Inspections. Medical inspections of internees shall be made at least once a month. Their purpose shall be, in particular, to supervise the general state of health, nutrition, and cleanliness of the internees, and to detect contagious diseases, especially tuberculosis, malaria, and venereal diseases. Such inspections shall include, in particular, the checking of the weight of each internee, and, at least once a year, a radioscopic examination. Chapter 5. Religious, Intellectual, and Physical Activities. Article 93. Religious Duties. Internees shall enjoy complete latitude in the exercise of their religious duties, including attendance at the services of their faith, on condition that they comply with the disciplinary routine prescribed by the detaining authorities. Ministers of religion who are interned shall be allowed to minister freely to the members of their community. For this purpose, the detaining power shall ensure their equitable allocation amongst the various places of internment in which there are internees speaking the same language and belonging to the same religion. Should such ministers be too few in number, the detaining power shall provide them with the necessary facilities, including means of transport, for moving from one place to another, and they shall be authorized to visit any internees who are in hospital. Ministers of religion shall be at liberty to correspond on matters concerning their ministry with the religious authorities in the country of detention, and, as far as possible, with the international religious organizations of their faith. Such correspondence shall not be considered as forming a part of the quota mentioned in Article 107. It shall, however, be subject to the provisions of Article 112. When internees do not have at their disposal the assistance of ministers of their faith, or should these latter be too few in number, the local religious authorities of the same faith may appoint, in agreement with the detaining power, a minister of the internee's faith, or, if such a course is feasible from a denominational point of view, a minister of similar religion or a qualified layman. The latter shall enjoy the facilities granted to the ministry he has assumed. Persons so appointed shall comply with all regulations laid down by the detaining power in the interests of discipline and security. Article 94. Recreation, study, sports, and games. The detaining power shall encourage intellectual, educational, and recreational pursuits, sports, and games amongst internees, whilst leaving them free to take part in them or not. It shall take all practicable measures to ensure the exercise thereof, in particular by providing suitable premises. All possible facilities shall be granted to internees to continue their studies or to take up new subjects. The education of children and young people shall be ensured. They shall be allowed to attend schools, either within the place of internment or outside. Internees shall be given opportunities for physical exercise, sports, and outdoor games. For this purpose, sufficient open spaces shall be set aside in all places of internment. Special playgrounds shall be reserved for children and young people. Article 95. Working conditions. The detaining power shall not employ internees as workers unless they so desire. Employment which, if undertaken under compulsion by a protected person not in internment, would involve a breach of Articles 40 or 51 of the present Convention, and employment on work which is of a degrading or humiliating character, are in any case prohibited. After a working period of 6 weeks, internees shall be free to give up work at any moment, subject to 8 days' notice. These provisions constitute no obstacle to the right of the detaining power to employ interned doctors, dentists, and other medical personnel in their professional capacity on behalf of their fellow internees, or to employ internees for administrative and maintenance work in places of internment, and to detail such persons for work in the kitchens or for other domestic tasks, or to require such persons to undertake duties connected with the protection of internees against aerial bombardment or other war risks. No internee may, however, be required to perform tasks for which he is, in the opinion of a medical officer, physically unsuited. The detaining power shall take entire responsibility for all working conditions, for medical attention, for the payment of wages, and for ensuring that all employed internees receive compensation for occupational accidents and diseases. The standards prescribed for the said working conditions and for compensation shall be in accordance with the national laws and regulations and with the existing practice. They shall in no case be inferior to those obtaining for work of the same nature in the same district. Wages for work done shall be determined on an equitable basis by special agreements between the internees, the detaining power, and, if the case arises, employers other than the detaining power, due regard being paid to the obligation of the detaining power to provide for free maintenance of internees and for the medical attention which their state of health may require. Internees permanently detailed for categories of work mentioned in the 3rd paragraph of this article shall be paid fair wages by the detaining power. the working conditions and the scale of compensation for occupational accidents and diseases to internees thus detailed shall not be inferior to those applicable to work of the same nature in the same district. Article 96. Labor detachments. All labor detachments shall remain part of and dependent upon a place of internment. The competent authorities of the detaining power and the commandant of a place of internment shall be responsible for the observance in a labor detachment of the provisions of the present convention. The commandant shall keep an up-to-date list of the labor detachments subordinate to him, and shall communicate it to the delegates of the protecting power, of the International Committee of the Red Cross, and of other humanitarian organizations who may visit places of internment. Chapter 6. Personal Property and Financial Resources. Article 97. Valuables and Personal Effects. Internees shall be permitted to retain articles of personal use. Moneys, checks, bonds, etc., and valuables in their possession may not be taken from them except in accordance with established procedure. Detailed receipts shall be given therefor. The amounts shall be paid into the account of every internee as provided for in Article 98. Such amounts may not be converted into any other currency unless legislation in force in the territory in which the owner is interned so requires, or the internee gives his consent. Articles which have, above all, a personal or sentimental value may not be taken away. A woman internee shall not be searched except by a woman. On release or repatriation, internees shall be given all articles, monies, or other valuables taken from them during internment, and shall receive in currency the balance of any credit to their accounts kept in accordance with Article 98, with the exception of any articles or amounts withheld by the detaining power by virtue of its legislation in force. If the property of an internee is so withheld, the owner shall receive a detailed receipt. Family or identity documents in the possession of internees may not be taken away without a receipt being given. At no time shall internees be left without identity documents. If they have none, they shall be issued with special documents drawn up by the detaining authorities, which will serve as their identity papers until the end of their internment. Internees may keep on their persons a certain amount of money, in cash or in the shape of purchase coupons, to enable them to make purchases. Article 98. Financial Resources and Individual Accounts. All internees shall receive regular allowances sufficient to enable them to purchase goods and articles, such as tobacco, toilet requisites, etc. Such allowances may take the form of credits or purchase coupons. Furthermore, internees may receive allowances from the power to which they owe allegiance, the protecting powers, the organizations which may assist them, or their families, as well as the income on their property in accordance with the law of the detaining power. The amount of allowances granted by the power to which they owe allegiance shall be the same for each category of internees, infirm, sick, pregnant women, etc., but may not be allocated by that power or distributed by the detaining power on the basis of discrimination between internees, which are prohibited by Article 27 of the present Convention. The detaining power shall open a regular account for every internee, to which shall be credited the allowances named in the present article, the wages earned, and the remittances received, together with such sums taken from him as may be available under the legislation in force in the territory in which he is interned. Internees shall be granted all facilities consistent with the legislation in force in such territory to make remittances to their families and to other dependents. They may draw from their accounts the amounts necessary for their personal expenses, within the limits fixed by the detaining power. They shall at all times be afforded reasonable facilities for consulting and obtaining copies of their accounts. A statement of accounts shall be furnished to the protecting power on request, and shall accompany the internee in case of transfer. Chapter 7. Administration and Discipline. Article 99. Camp Administration, Posting of the Convention and of Orders. Every place of internment shall be put under the authority of a responsible officer chosen from the regular military forces or the regular civil administration of the detaining power. The officer in charge of the place of internment must have in his possession a copy of the present convention in the official language or one of the official languages of his country, and shall be responsible for its application. The staff in control of internees shall be instructed in the provisions of the present convention and of the administrative measures adopted to ensure its application. The text of the present convention and the texts of any special agreements concluded under said convention shall be posted inside the place of internment in a language which the internees understand, or shall be in the possession of the internee committee. Regulations, orders, notices, and publications of every kind shall be communicated to the internees and posted inside the places of internment in a language which they understand. Every order and command addressed to internees individually must likewise be given in a language which they understand. Article 100. General Discipline. The disciplinary regime in places of internment shall be consistent with humanitarian principles, and shall in no circumstances include regulations imposing on internees any physical exertion dangerous to their health, or involving physical or moral victimization. Identification by tattooing or imprinting signs or markings on the body is prohibited. In particular, prolonged standing and roll calls, punishment drill, military drill and maneuvers, or the reduction of food rations are prohibited. Article 101. Complaints and Petitions. Internees shall have the right to present to the authorities in whose power they are any petition with regard to the conditions of internment to which they are subjected. They shall also have the right to apply without restriction through the internee committee, or, if they consider it necessary, direct to the representatives of the protecting power in order to indicate to them any points on which they may have complaints to make with regard to the conditions of internment. Such petitions and complaints shall be transmitted forthwith and without alteration, and even if the latter are recognized to be unfounded, they may not occasion any punishment. Periodic reports on the situation in places of internment, and as to the needs of the internees, may be sent by the internee committees to the representatives of the protecting powers. Article 102. Internee Committees. 1. Election of members. In every place of internment, the internees shall freely elect by secret ballot every 6 months the members of a committee empowered to represent them before the detaining and the protecting powers, the International Committee of the Red Cross, and any other organization which may assist them. The members of the committee shall be eligible for re-election. Internees so elected shall enter upon their duties after the election has been approved by the detaining authorities. The reasons for any refusals or dismissals shall be communicated to the protecting powers concerned. Article 103. 2. Duties. The internee committees shall further the physical, spiritual, and intellectual well-being of the internees. In case the internees decide in particular to organize a system of mutual assistance amongst themselves, this organization would be within the competence of the committees, in addition to the special duties entrusted to them under other provisions of the present convention. Article 104. 3. Prerogatives. Members of internee committees shall not be required to perform any other work if the accomplishment of their duties is rendered more difficult thereby. Members of internee committees may appoint from amongst the internees such assistants as they may require. All material facilities shall be granted to them, particularly a certain freedom of movement necessary for the accomplishment of their duties, visits to labor detachments, receipt of supplies, etc. All facilities shall likewise be accorded to members of internee committees for communication by post and telegraph with the detaining authorities, the protecting powers, the International Committee of the Red Cross and their delegates, and with the organizations which give assistance to internees. Committee members in labor detachments shall enjoy similar facilities for communication with their internee committee in their principal place of internment. Such communications shall not be limited nor considered as forming a part of the quota mentioned in Article 107. Members of internee committees who are transferred shall be allowed a reasonable time to acquaint their successors with current affairs. Chapter 8. Relations with the Exterior. Article 105. Notification of measures taken. Immediately upon interning protected persons, the detaining powers shall inform them, the power to which they owe allegiance, and their protecting power, of the measures taken for executing the provisions of the present chapter. The detaining powers shall likewise inform the parties concerned of any subsequent modifications of such measures. Article 106. Internment Card. As soon as he is interned, or at the latest not more than 1 week after his arrival in a place of internment, and likewise in cases of sickness or transfer to another place of internment or to a hospital, every internee shall be enabled to send direct to his family on the one hand, and to the central agency provided for by Article 140 on the other, an internment card, similar if possible to the model annexed to the present convention, informing his relatives of his detention, address, and state of health. The said cards shall be forwarded as rapidly as possible and may not be delayed in any way. Article 107. Correspondence. Internees shall be allowed to send and receive letters and cards. If the detaining power deems it necessary to limit the number of letters and cards sent by each internee, the said number shall not be less than 2 letters and 4 cards monthly. These shall be drawn up so as to conform as closely as possible to the models annexed to the present convention. If limitations must be placed on the correspondence addressed to internees, they may be ordered only by the power to which such internees owe allegiance, possibly at the request of the detaining power. Such letters and cards must be conveyed with reasonable dispatch. They may not be delayed or retained for disciplinary reasons. Internees who have been a long time without news, or who find it impossible to receive news from their relatives or to give them news by the ordinary postal route, as well as those who are at a considerable distance from their homes, shall be allowed to send telegrams, the charges being paid by them in the currency at their disposal. They shall likewise benefit by this provision in cases which are recognized to be urgent. As a rule, internees' mail shall be written in their own language. The parties to the conflict may authorize correspondence in other languages. Article 108. Relief Shipments. 1. General Principles. Internees shall be allowed to receive, by post or by any other means, individual parcels or collective shipments containing, in particular, foodstuffs, clothing, medical supplies, as well as books and objects of a devotional, educational, or recreational character which may meet their needs. Such shipments shall in no way free the detaining power from the obligations imposed upon it by virtue of the present convention. Should military necessity require the quantity of such shipments to be limited, due notice thereof shall be given to the protecting power and to the International Committee of the Red Cross, or to any other organization giving assistance to the internees and responsible for the forwarding of such shipments. The conditions for the sending of individual parcels and collective shipments shall, if necessary, be the subject of special agreements between the powers concerned, which may in no case delay the receipt by the internees of relief supplies. Parcels of clothing and foodstuffs may not include books. Medical relief supplies shall, as a rule, be sent in collective parcels. Article 109. 2. Collective relief. In the absence of special agreements between parties to the conflict regarding the conditions for the receipt and distribution of collective relief shipments, the regulations concerning collective relief which are annexed to the present convention shall be applied. The special agreements provided for above shall in no case restrict the right of internee committees to take possession of collective relief shipments intended for the internees, to undertake their distribution, and to dispose of them in the interests of the recipients. Nor shall such agreements restrict the right of representatives of the protecting powers, the International Committee of the Red Cross, or any other organization giving assistance to internees and responsible for the forwarding of collective shipments, to supervise their distribution to the recipients. Article 110. 3. Exemption from postal and transport charges. All relief shipments for internees shall be exempt from import, customs, and other dues. All matter sent by mail, including relief parcels sent by parcel post and remittances of money addressed from other countries to internees or dispatched by them through the post office, either direct or through the Information Bureau provided for in Article 136 and the Central Information Agency provided for in Article 140, shall be exempt from all postal dues both in the countries of origin and destination and intermediate countries. To this end, in particular, the exemption provided by the Universal Postal Convention of 1947 and by the agreements of the Universal Postal Union in favor of civilians of enemy nationality detained in camps or civilian prisons, shall be extended to the other interned persons protected by the present convention. The countries not signatory to the above-mentioned agreements shall be bound to grant freedom from charges in the same circumstances. The cost of transporting relief shipments which are intended for internees, and which, by reason of their weight or any other cause, cannot be sent through the post office, shall be borne by the detaining power in all the territories under its control. Other powers which are parties to the present convention shall bear the cost of transport in their respective territories. Costs connected with the transport of such shipments which are not covered by the above paragraphs shall be charged to the senders. The high contracting parties shall endeavor to reduce, so far as possible, the charges for telegrams sent by internees or addressed to them. Article 111. Special means of transport. Should military operations prevent the powers concerned from fulfilling their obligation to ensure the conveyance of the mail and relief shipments provided for in Articles 106, 107, 108, and 113, the protecting powers concerned, the International Committee of the Red Cross, or any other organization duly approved by the parties to the conflict, may undertake the conveyance of such shipments by suitable means, rail, motor vehicles, vessels, or aircraft, etc. For this purpose, the high contracting parties shall endeavor to supply them with such transport, and to allow its circulation, especially by granting the necessary safe conducts. Such transport may also be used to convey a. Correspondence, lists, and reports exchanged between the Central Information Agency referred to in Article 140 and the National Bureau referred to in Article 136. b. Correspondence and reports relating to internees, which the protecting powers, the International Committee of the Red Cross, or any other organization assisting the internees, exchange either with their own delegates or with the parties to the conflict. These provisions in no way detract from the right of any party to the conflict to arrange other means of transport if it should so prefer, nor preclude the granting of safe conducts under mutually agreed conditions to such means of transport. The costs occasioned by the use of such means of transport shall be borne in proportion to the importance of the shipments by the parties to the conflict whose nationals are benefited thereby. Article 112. Censorship and Examination. The censoring of correspondence addressed to internees or dispatched by them shall be done as quickly as possible. The examination of consignments intended for internees shall not be carried out under conditions that will expose the goods contained in them to deterioration. It shall be done in the presence of the addressee or of a fellow internee duly delegated by him. The delivery to internees of individual or collective consignments shall not be delayed under the pretext of difficulties of censorship. Any prohibition of correspondence ordered by the parties to the conflict, either for military or political reasons, shall be only temporary, and its duration shall be as short as possible. Article 113. Execution and transmission of legal documents. The detaining powers shall provide all reasonable facilities for the transmission through the protecting power or the central agency provided for in Article 140, or as otherwise required, of wills, powers of attorney, letters of authority, or any other documents intended for internees or dispatched by them. In all cases, the detaining powers shall facilitate the execution and authentication in due legal form of such documents on behalf of internees, in particular by allowing them to consult a lawyer. Article 114. Management of property. The detaining power shall afford internees all facilities to enable them to manage their property, provided this is not incompatible with the conditions of internment and the law which is applicable. For this purpose, the said power may give them permission to leave the place of internment in urgent cases and if circumstances allow. Article 115. Facilities for preparation and conduct of cases. In all cases where an internee is a party to proceedings in any court, the detaining power shall, if he so requests, cause the court to be informed of his detention, and shall, within legal limits, ensure that all necessary steps are taken to prevent him from being in any way prejudiced by reason of his internment, as regards the preparation and conduct of his case, or as regards the execution of any judgment of the court. Article 116. Visits. Every internee shall be allowed to receive visitors, especially near relatives, at regular intervals and as frequently as possible. As far as is possible, internees shall be permitted to visit their homes in urgent cases, particularly in cases of the death or serious illness of relatives. End of Section 26. Recording by Maria Kasper. Section 27 of Geneva Conventions, August 1949. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 3, Status and Treatment of Protected Persons, Section 4, Chapters 9 through 12. Chapter 9, Penal and Disciplinary Sanctions. Article 117, General Provisions, Applicable Legislation. Subject to the provisions of the present chapter, the laws in force in the territory in which they are detained will continue to apply to internees who commit offenses during internment. If general laws, regulations, or orders declare acts committed by internees to be punishable, whereas the same acts are not punishable when committed by persons who are not internees, such acts shall entail disciplinary punishments only. No internee may be punished more than once for the same act or on the same count. Article 118. Penalties. The courts or authorities shall in passing sentence take as far as possible into account the fact that the defendant is not a national of the detaining power. They shall be free to reduce the penalty prescribed for the offense with which the internee is charged, and shall not be obliged, to this end, to apply the minimum sentence prescribed. Imprisonment in premises without daylight, and in general all forms of cruelty without exception, are forbidden. Internees who have served disciplinary or judicial sentences shall not be treated differently from other internees. The duration of preventive detention undergone by an internee shall be deducted from any disciplinary or judicial penalty involving confinement to which he may be sentenced. Internee committees shall be informed of all judicial proceedings instituted against internees whom they represent and of their result. Article 119. Disciplinary punishments. The disciplinary punishments applicable to internees shall be the following. 1. A fine, which shall not exceed 50% of the wages which the internee would otherwise receive under the provisions of Article 95 during a period of not more than 30 days. 2. Discontinuance of privileges granted over and above the treatment provided for by the present Convention. 3. Fatigue duties not exceeding 2 hours daily in connection with the maintenance of the place of internment. 4. Confinement. In no case shall disciplinary penalties be inhuman, brutal, or dangerous for the health of the internees. Account shall be taken of the internee's age, sex, and state of health. The duration of any single punishment shall in no case exceed a maximum of 30 consecutive days, even if the internee is answerable for several breaches of discipline when his case is dealt with, whether such breaches are connected or not. Article 120. Escapes. Internees who are recaptured after having escaped or when attempting to escape shall be liable only to disciplinary punishment in respect of this act, even if it is a repeated offense. Article 118, paragraph 3 notwithstanding, internees punished as a result of escape or attempt to escape may be subjected to special surveillance on condition that such surveillance does not affect the state of their health, that it is exercised in the place of internment, and that it does not entail the abolition of any of the safeguards granted by the present Convention. Internees who aid and abet an escape or attempt to escape shall be liable on this count to disciplinary punishment only. Article 121. Connected offenses. Escape or attempt to escape, even if it is a repeated offense, shall not be deemed an aggravating circumstance in cases where an internee is prosecuted for offenses committed during his escape. The parties to the conflict shall ensure that the competent authorities exercise leniency in deciding whether punishment inflicted for an offense shall be of a disciplinary or a judicial nature, especially in respect of acts committed in connection with an escape, whether successful or not. Article 122. Investigations, confinement awaiting hearing. Acts which constitute offenses against discipline shall be investigated immediately. This rule shall be applied in particular in cases of escape or attempt to escape. Recaptured internees shall be handed over to the competent authorities as soon as possible. In cases of offenses against discipline, confinement awaiting trial shall be reduced to an absolute minimum for all internees, and shall not exceed 14 days. Its duration shall in any case be deducted from any sentence of confinement. The provisions of Articles 124 and 125 shall apply to internees who are in confinement awaiting trial for offenses against discipline. Article 123. Competent authorities. Procedure. Without prejudice to the competence of courts and higher authorities, disciplinary punishment may be ordered only by the commandant of the place of internment, or by a responsible officer or official who replaces him, or to whom he has delegated his disciplinary powers. Before any disciplinary punishment is awarded, the accused internee shall be given precise information regarding the offenses of which he is accused, and given an opportunity of explaining his conduct and of defending himself. He shall be permitted, in particular, to call witnesses, and to have recourse, if necessary, to the services of a qualified interpreter. The decision shall be announced in the presence of the accused and a member of the internee committee. The period elapsing between the time of award of a disciplinary punishment and its execution shall not exceed 1 month. When an internee is awarded a further disciplinary punishment, a period of at least 3 days shall elapse between the execution of any 2 of the punishments, if the duration of one of these is 10 days or more. A record of disciplinary punishments shall be maintained by the commandant of the place of internment, and shall be open to inspection by representatives of the protecting power. Article 124. Premises for disciplinary punishments. Internees shall not in any case be transferred to penitentiary establishments, prisons, penitentiaries, convict prisons, etc., to undergo disciplinary punishments therein. The premises in which disciplinary punishments are undergone shall conform to sanitary requirements. They shall in particular be provided with adequate bedding. Internees undergoing punishment shall be enabled to keep themselves in a state of cleanliness. Women internees undergoing disciplinary punishment shall be confined in separate quarters from male internees and shall be under the immediate supervision of women. Article 125. Essential safeguards. Internees awarded disciplinary punishment shall be allowed to exercise and to stay in the open air at least 2 hours daily. They shall be allowed, if they so request, to be present at the daily medical inspections. They shall receive the attention which their state of health requires, and if necessary shall be removed to the infirmary of the place of internment or to a hospital. They shall have permission to read and write, likewise to send and receive letters. Parcels and remittances of money, however, may be withheld from them until the completion of their punishment. Such consignments shall meanwhile be entrusted to the internee committee, who will hand over to the infirmary the perishable goods contained in the parcels. No internee given a disciplinary punishment may be deprived of the benefit of the provisions of Article 107 and 143 of the present Convention. Article 126. Provisions applicable to judicial proceedings. The provisions of Articles 71 to 76 inclusive shall apply by analogy to proceedings against internees who are in the national territory of the detaining power. Chapter 10. Transfers of internees. Article 127. Conditions. The transfer of internees shall always be effected humanely. As a general rule, it shall be carried out by rail or other means of transport, and under conditions at least equal to those obtaining for the forces of the detaining power in their changes of station. If, as an exceptional measure, such removals have to be effected on foot, they may not take place unless the internees are in a fit state of health, and may not in any case expose them to excessive fatigue. The detaining power shall supply internees during transfer with drinking water and food sufficient in quantity, quality, and variety to maintain them in good health, and also with the necessary clothing, adequate shelter, and the necessary medical attention. The detaining power shall take all suitable precautions to ensure their safety during the transfer, and shall establish before their departure a complete list of all internees transferred. Sick, wounded, or infirm internees and maternity cases shall not be transferred if the journey would be seriously detrimental to them, unless their safety imperatively so demands. If the combat zone draws close to a place of internment, the internees in the said place shall not be transferred unless their removal can be carried out in adequate conditions of safety, or unless they are exposed to greater risks by remaining on the spot than by being transferred. When making decisions regarding the transfer of internees, the detaining power shall take their interests into account, and in particular shall not do anything to increase the difficulties of repatriating them or returning them to their own homes. Article 128. Method. In the event of transfer, internees shall be officially advised of their departure and of their new postal address. Such notification shall be given in time for them to pack their luggage and inform their next of kin. They shall be allowed to take with them their personal effects and the correspondence and parcels which have arrived for them. The weight of such baggage may be limited if the conditions of the transfer so require, but in no case to be less than 25 kilograms per internee. Mail and parcels addressed to their former place of internment shall be forwarded to them without delay. The Commandant of the place of internment shall take, in agreement with the internee committee, any measures needed to ensure the transport of the internee's community property and of the luggage the internees are unable to take with them in consequence of restrictions imposed by virtue of the second paragraph. Chapter 11. Deaths. Article 129. Wills, death certificates. The wills of internees shall be received for safekeeping by responsible authorities, and in the event of the death of an internee, his will shall be transmitted without delay to a person whom he has previously designated. Deaths of internees shall be certified in every case by a doctor, and a death certificate shall be made out showing the causes of death and the conditions under which it occurred. An official record of the death, duly registered, shall be drawn up in accordance with the procedure relating thereto in force in the territory where the place of internment is situated, and a duly certified copy of such record shall be transmitted without delay to the protecting power as well as to the central agency referred to in Article 140. Article 130. Burial, cremation. The detaining authorities shall ensure that internees who die while interned are honorably buried, if possible according to the rites of the religion to which they belonged, and that their graves are respected, properly maintained, and marked in such a way that they can always be recognized. Deceased internees shall be buried in individual graves, unless unavoidable circumstances require the use of collective graves. Bodies may be cremated only for imperative reasons of hygiene, on account of the religion of the deceased, or in accordance with his expressed wish to this effect. In case of cremation, the fact shall be stated and the reasons given in the death certificate of the deceased. The ashes shall be retained for safekeeping by the detaining authorities, and shall be transferred as soon as possible to the next of kin on their request. As soon as circumstances permit, and not later than the close of hostilities, the detaining power shall forward lists of graves of deceased internees to the powers on whom the deceased internees depended through the Information Bureau provided for in Article 136. Such lists shall include all particulars necessary for the identification of the deceased internees, as well as the exact location of their graves. Article 131. Internees killed or injured in special circumstances. Every death or serious injury of an internee caused or suspected to have been caused by a sentry, another internee, or any other person, as well as any death the cause of which is unknown, shall be immediately followed by an official inquiry by the detaining power. A communication on this subject shall be sent immediately to the protecting power. The evidence of any witnesses shall be taken, and a report including such evidence shall be prepared and forwarded to the said protecting power. If the inquiry indicates the guilt of one or more persons, the detaining power shall take all necessary steps to ensure the prosecution of the person or persons responsible. Chapter 12. Release, repatriation, and accommodation in neutral countries. Article 132. During hostilities or occupation. Each interned person shall be released by the detaining power as soon as the reasons which necessitated his internment no longer exist. The parties to the conflict shall, moreover, endeavor during the course of hostilities to conclude agreements for the release, the repatriation, the return to places of residence, or the accommodation in a neutral country of certain classes of internees, in particular children, pregnant women, and mothers with infants and young children, the wounded and sick, and internees who have been detained for a long time. Article 133. After the close of hostilities. Internment shall cease as soon as possible after the close of hostilities. Internees in the territory of a party to the conflict, against whom penal proceedings are pending for offenses not exclusively subject to disciplinary penalties, may be detained until the close of such proceedings, and, if circumstances require, until the completion of the penalty. The same shall apply to internees who have been previously sentenced to a punishment depriving them of liberty. By agreement between the detaining power and the powers concerned, committees may be set up after the close of hostilities or of the occupation of territories to search for dispersed internees. Article 134. Repatriation and return to last place of residence. The high contracting parties shall endeavor, upon the close of hostilities or occupation, to ensure the return of all internees to their last place of residence or to facilitate their repatriation. Article 135. Costs. The detaining power shall bear the expense of returning released internees to the places where they were residing when interned, or, if it took them into custody while they were in transit or on the high seas, the cost of completing their journey or of their return to the point of departure. Where a detaining power refuses permission to reside in its territory to a released internee who previously had had his permanent domicile therein, such detaining power shall pay the cost of said internee's repatriation. If, however, the internee elects to return to his country on his own responsibility, or in obedience to the government of the power to which he owes allegiance, the detaining power need not pay the expenses of his journey beyond the point of his departure from its own territory. The detaining power need not pay the costs of repatriation of an internee who was interned at his own request. If internees are transferred in accordance with Article 45, the transferring and receiving powers shall agree on the portion of the above costs to be borne by each. The foregoing shall not prejudice such special agreements as may be concluded between parties to the conflict concerning the exchange and repatriation of their nationals in enemy hands. End of Section 27. Recording by Maria Kasper. Section 28 of Geneva Conventions, August 1949. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 3. Status and Treatment of Protected Persons. Section 5. Information Bureau and Central Agency. Article 136. National Bureaus. Upon the outbreak of a conflict, and in all cases of occupation, each of the parties to the conflict shall establish an official information bureau responsible for receiving and transmitting information in respect of the protected persons who are in its power. Each of the parties to the conflict shall, within the shortest possible period, give its bureau information of any measure taken by it concerning any protected persons who are kept in custody for more than 2 weeks, who are subjected to assigned residence, or who are interned. It shall furthermore require its various departments concerned with such matters to provide the aforesaid Bureau promptly with information concerning all changes pertaining to these protected persons, as for example, transfers, releases, repatriations, escapes, admittances to hospitals, births, and deaths. Article 137. Transmission of information. Each National Bureau shall immediately forward information concerning protected persons by the most rapid means to the powers of whom the aforesaid persons are nationals, or to powers in whose territory they resided, through the intermediary of the protecting powers, and likewise through the central agency provided for in Article 140. The Bureau shall also reply to all inquiries which may be received regarding protected persons. Information bureaus shall transmit information concerning a protected person, unless its transmission might be detrimental to the person concerned or to his or her relatives. Even in such a case, the information may not be withheld from the central agency, which, upon being notified of the circumstances, will take the necessary precautions indicated in Article 140. All communications in writing made by any bureau shall be authenticated by a signature or a seal. Article 138. Particulars required. The information received by the National Bureau and transmitted by it shall be of such a character as to make it possible to identify the protected person exactly and to advise his next of kin quickly. The information in respect of each person shall include at least his surname, first names, place and date of birth, nationality, last residence, and distinguishing characteristics, the first name of the father and the maiden name of the mother, the date, place, and nature of the action taken with regard to the individual, the address at which correspondence may be sent to him, and the name and address of the person to be informed. Likewise, information regarding the state of health of internees who are seriously ill or seriously wounded shall be supplied regularly and, if possible, every week. Article 139. Forwarding of personal valuables. Each National Information Bureau shall furthermore be responsible for collecting all personal valuables left by protected persons mentioned in Article 136, in particular those who have been repatriated or released, or who have escaped or died. It shall forward the said valuables to those concerned, either direct, or, if necessary, through the central agency. Such articles shall be sent by the Bureau in sealed packets, which shall be accompanied by statements giving clear and full identity particulars of the person to whom the articles belonged, and by a complete list of the contents of the parcel. Detailed records shall be maintained of the receipt and dispatch of all such valuables. Article 140. Central Agency. A central information agency for protected persons, in particular for internees, shall be created in a neutral country. The International Committee of the Red Cross shall, if it deems necessary, propose to the powers concerned the organization of such an agency, which may be the same as that provided for in Article 123 of the Geneva Convention relative to the treatment of prisoners of war of August 12, 1949. The function of the agency shall be to collect all information of the type set forth in Article 136, which it may obtain through official or private channels, and to transmit it as rapidly as possible to the countries of origin or of residence of the persons concerned, except in cases where such transmissions might be detrimental to the persons whom the said information concerns or to their relatives. It shall receive from the parties to the conflict all reasonable facilities for effecting such transmissions. The high contracting parties, and in particular those whose nationals benefit by the services of the central agency, are requested to give the said agency the financial aid it may require. The foregoing provisions shall in no way be interpreted as restricting the humanitarian activities of the International Committee of the Red Cross or of the relief societies described in Article 142. Article 141. Exemption from charges. The National Information Bureau and the Central Information Agency shall enjoy free postage for all mail, likewise the exemptions provided for in Article 110, and further, so far as possible, exemption from telegraphic charges or at least greatly reduced rates. End of Section 28. Recording by Maria Kasper. Section 29 of Geneva Conventions, August 1949. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 4. Execution of the Convention. Section 1. General Provisions. Article 142. Relief Societies and Other Organizations. Subject to the measures which the detaining powers may consider essential to ensure their security or to meet any other reasonable need, the representatives of religious organizations, relief societies, or any other organizations assisting the protected persons shall receive from these powers, for themselves or their duly accredited agents, all facilities for visiting the protected persons, for distributing relief supplies and material from any source, intended for educational, recreational, or religious purposes, or for assisting them in organizing their leisure time within the places of internment. Such societies or organizations may be constituted in the territory of the detaining power or in any other country, or they may have an international character. The detaining power may limit the number of societies and organizations whose delegates are allowed to carry out their activities in its territory and under its supervision, on condition, however, that such limitation shall not hinder the supply of effective and adequate relief to all protected persons. The special position of the International Committee of the Red Cross in this field shall be recognized and respected at all times. Article 143. Supervision. Representatives or delegates of the protecting powers shall have permission to go to all places where protected persons are, particularly to places of internment, detention, and work. They shall have access to all premises occupied by protected persons, and shall be able to interview the latter without witnesses, personally or through an interpreter. Such visits may not be prohibited, except for reasons of imperative military necessity, and then only as an exceptional temporary measure. Their duration and frequency shall not be restricted. Such representatives and delegates shall have full liberty to select the places they wish to visit. The detaining or occupying power, the protecting power, and when occasion arises the power of origin of the persons to be visited, may agree that compatriots of the internees shall be permitted to participate in the visits. The delegates of the International Committee of the Red Cross shall also enjoy the above prerogatives. The appointment of such delegates shall be submitted to the approval of the power governing the territories where they will carry out their duties. Article 144. Dissemination of the Convention. The high contracting parties undertake, in time of peace as in time of war, to disseminate the text of the present convention as widely as possible in their respective countries, and in particular to include the study thereof in their programs of military, and if possible civil, instruction, so that the principles thereof may become known to the entire population. Any civilian, military, police, or other authorities who in time of war assume responsibilities in respect of protected persons must possess the text of the Convention and be specially instructed as to its provisions. Article 145. Translations, Rules of Application. The high contracting parties shall communicate to one another through the Swiss Federal Council, and during hostilities through the protecting powers, the official translations of the present convention, as well as the laws and regulations which they may adopt to ensure the application thereof. Article 146. Penal Sanctions. 1. General Observations. The high contracting parties undertake to enact any legislation necessary to provide effective penal sanctions for persons committing or ordering to be committed any of the grave breaches of the present convention defined in the following article. Each high contracting party shall be under the obligation to search for persons alleged to have committed or to have ordered to be committed such grave breaches, and shall bring such persons, regardless of their nationality, before its own courts. It may also, if it prefers, and in accordance with the provisions of its own legislation, hand such persons over for trial to another high contracting party concerned, provided such high contracting party has made out a prima facie case. Each high contracting party shall take measures necessary for the suppression of all acts contrary to the provisions of the present convention, other than the grave breaches defined in the following article. In all circumstances, the accused persons shall benefit by safeguards of proper trial and defense, which shall not be less favorable than those provided by Article 105 and those following the Geneva Convention relative to the treatment of prisoners of war of August 12, 1949. Article 147. Penal sanctions. 2. Grave breaches. Grave breaches, to which the preceding article relates, shall be those involving any of the following acts, if committed against persons or property protected by the present convention: willful killing, torture, or inhuman treatment, including biological experiments, willfully causing great suffering or serious injury to body or health, unlawful deportation or transfer or unlawful confinement of a protected person, compelling a protected person to serve in the forces of a hostile power, or willfully depriving a protected person of the rights of fair and regular trial prescribed in the present convention, taking of hostages, and extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly. Article 148. Penal sanctions. 3. Responsibilities of the contracting parties. No high contracting party shall be allowed to absolve itself or any other high contracting party of any liability incurred by itself or by another high contracting party in respect of breaches referred to in the preceding article. Article 149. Inquiry procedure. At the request of a party to the conflict, an inquiry shall be instituted in a manner to be decided between the interested parties concerning any alleged violation of the convention. If agreement has not been reached concerning the procedure for the inquiry, the parties should agree on the choice of an umpire who will decide upon the procedure to be followed. Once the violation has been established, the parties to the conflict shall put an end to it and shall repress it with the least possible delay. Section 2. Final provisions. Article 150. Languages. The present convention is established in English and in French. Both texts are equally authentic. The Swiss Federal Council shall arrange for official translations of the convention to be made in the Russian and Spanish languages. Article 151. Signature. The present convention, which bears the date of this day, is open to signature until February 12, 1950, in the name of the powers represented at the conference which opened at Geneva on April 21, 1949. Article 152. Ratification. The present convention shall be ratified as soon as possible, and the ratification shall be deposited at Berne. A record shall be drawn up of the deposit of each instrument of ratification, and certified copies of this record shall be transmitted by the Swiss Federal Council to all the powers in whose name the convention has been signed, or whose accession has been notified. Article 153. Coming into force. The present convention shall come into force 6 months after not less than 2 instruments of ratification have been deposited. Thereafter it shall come into force for each high contracting party 6 months after the deposit of the instrument of ratification. Article 154. Relation with the Hague Conventions. In the relations between the powers who are bound by the Hague Conventions respecting the laws and customs of war on land, whether that of July 29, 1899, or that of October 18, 1907, and who are parties to the present convention, this last convention shall be supplementary to sections 2 and 3 of the regulations annexed to the above-mentioned Conventions of The Hague. Article 155. Accession. From the date of its coming into force, it shall be open to any power in whose name the present convention has not been signed to accede to this convention. Article 156. Notification of accessions. Accessions shall be notified in writing to the Swiss Federal Council and shall take effect 6 months after the date on which they are received. The Swiss Federal Council shall communicate the accessions to all the powers in whose name the convention has been signed or whose accession has been notified. Article 157. Immediate effect. The situations provided for in Articles 2 and 3 shall give immediate effect to ratifications deposited and accessions notified by the parties to the conflict before or after the beginning of hostilities and occupation. The Swiss Federal Council shall communicate by the quickest method any ratifications or accessions received from parties to the conflict. Article 158. Denunciation. Each of the high contracting parties shall be at liberty to denounce the present convention. The denunciation shall be notified in writing to the Swiss Federal Council, which shall transmit it to the governments of all the high contracting parties. The denunciation shall take effect 1 year after the notification thereof has been made to the Swiss Federal Council. However, a denunciation of which notification has been made at a time when the denouncing power is involved in a conflict shall not take effect until peace has been concluded, and until after operations connected with the release, repatriation, and reestablishment of the persons protected by the present convention have been terminated. The denunciation shall have effect only in respect of the denouncing power. It shall in no way impair the obligations which the parties to the conflict shall remain bound to fulfill by virtue of the principles of the law of nations, as they result from the usages established among civilized peoples, from the laws of humanity and the dictates of the public conscience. Article 159. Registration with the United Nations. The Swiss Federal Council shall register the present convention with the Secretariat of the United Nations. The Swiss Federal Council shall also inform the Secretariat of the United Nations of all ratifications, accessions, and denunciations received by it with respect to the present convention. In witness whereof the undersigned, having deposited their respective full powers, have signed the present convention. Done at Geneva this 12th day of August 1949 in the English and French languages. The original shall be deposited in the archives of the Swiss Confederation. The Swiss Federal Council shall transmit certified copies thereof to each of the signatory and acceding states. Annex 1. Draft Agreement relating to hospital and safety zones and localities. Article 1. Hospital and safety zones shall be strictly reserved for the persons mentioned in Article 23 of the Geneva Convention for the amelioration of the condition of the wounded and sick in armed forces in the field of August 12, 1949, and in Article 14 of the Geneva Convention relative to the protection of civilian persons in time of war of August 12, 1949, and for the personnel entrusted with the organization and administration of these zones and localities, and with the care of the persons therein assembled. Nevertheless, persons whose permanent residence is within such zones shall have the right to stay there. Article 2. No persons residing in whatever capacity in a hospital and safety zone shall perform any work, either within or without the zone, directly connected with military operations or the production of war material. Article 3. The power establishing a hospital and safety zone shall take all necessary measures to prohibit access to all persons who have no right of residence or entry therein. Article 4. Hospital and safety zones shall fulfill the following conditions. A. They shall comprise only a small part of the territory governed by the power which has established them. B. They shall be thinly populated in relation to the possibilities of accommodation. C. They shall be far removed and free from all military objectives or large industrial or administrative establishments. D. They shall not be situated in areas which, according to every probability, may become important for the conduct of the war. Article 5. Hospital and safety zones shall be subject to the following obligations. A. The lines of communication and means of transport which they possess shall not be used for the transport of military personnel or material, even in transit. B. They shall in no case be defended by military means. Article 6. Hospital and safety zones shall be marked by means of oblique red bands on a white ground placed on the buildings and outer precincts. Zones reserved exclusively for the wounded and sick may be marked by means of the Red Cross, Red Crescent, Red Lion and Sun emblem on a white ground. They may be similarly marked at night by means of appropriate illumination. Article 7. The powers shall communicate to all the high contracting parties in peacetime or on the outbreak of hostilities a list of the hospital and safety zones in the territories governed by them. They shall also give notice of any new zones set up during the hostilities. As soon as the adverse party has received the above-mentioned notification, the zone shall be regularly established. If, however, the adverse party considers that the conditions of the present agreement have not been fulfilled, it may refuse to recognize the zone by giving immediate notice thereof to the party responsible for the said zone, or may make its recognition of such zone dependent upon the institution of the control provided for in Article 8. Article 8. Any power having recognized one or several hospital and safety zones instituted by the adverse party shall be entitled to demand control by one or more special commissions for the purpose of ascertaining if the zones fulfill the conditions and obligations stipulated in the present agreement. For this purpose, members of the special commissions shall at all times have free access to the various zones, and may even reside there permanently. They shall be given all facilities for their duties of inspection. Article 9. Should the special commissions note any facts which they consider contrary to the stipulations of the present agreement, they shall at once draw the attention of the power governing the said zone to these facts, and shall fix a time limit of 5 days within which the matter shall be rectified. They shall duly notify the power who has recognized the zone. If, when the time limit has expired, the power governing the zone has not complied with the warning, the adverse party may declare that it is no longer bound by the present agreement in respect of said zone. Article 10. Any power setting up one or more hospital and safety zones, and the adverse parties to whom their existence has been notified, shall nominate or have nominated by the protecting powers or by other neutral powers persons eligible to be members of the special commissions mentioned in Articles 8 and 9. Article 11. In no circumstances may hospital and safety zones be the object of attack. They shall be protected and respected at all times by the parties to the conflict. Article 12. In the case of occupation of a territory, the hospital and safety zones therein shall continue to be respected and utilized as such. Their purpose may, however, be modified by the occupying power on condition that all measures are taken to ensure the safety of the persons accommodated. Article 13. The present agreement shall also apply to localities which the powers may utilize for the same purposes as hospital and safety zones. Annex 2. Draft Regulations concerning collective relief. Article 1. The internee committees shall be allowed to distribute collective relief shipments, for which they are responsible, to all internees who are dependent for administration on the said committee's place of internment, including those internees who are in hospitals or in prisons or other penitentiary establishments. Article 2. The distribution of collective relief shipments shall be effected in accordance with the instructions of the donors and with a plan drawn up by the internee committees. The issue of medical stores shall, however, be made for preference in agreement with the senior medical officers, and the latter may, in hospitals and infirmaries, waive the said instructions if the needs of their patients so demand. Within the limits thus defined, the distribution shall always be carried out equitably. Article 3. Members of internee committees shall be allowed to go to the railway stations or other points of arrival of relief supplies near their places of internment, so as to enable them to verify the quantity as well as the quality of the goods received, and to make out detailed reports thereon for the donors. Article 4. Internee committees shall be given the facilities necessary for verifying whether the distribution of collective relief in all subdivisions and annexes of their places of internment has been carried out in accordance with their instructions. Article 5. Internee committees shall be allowed to complete and to cause to be completed by members of the internee committees in labor detachments or by the senior medical officers of infirmaries and hospitals forms or questionnaires intended for the donors relating to collective relief supplies, distribution requirements, quantities, etc. Such forms and questionnaires duly completed shall be forwarded to the donors without delay. Article 6. In order to secure the regular distribution of collective relief supplies to the internees in their place of internment, and to meet any needs that may arise through the arrival of fresh parties of internees, the internee committees shall be allowed to create and maintain sufficient reserve stocks of collective relief. For this purpose they shall have suitable warehouses at their disposal. Each warehouse shall be provided with 2 locks, the internee committee holding the keys of one lock, and the commandant of the place of internment the keys of the other. Article 7. The high contracting parties, and the detaining powers in particular, shall, so far as is in any way possible, and subject to the regulations governing the food supply of the population, authorize purchases of goods to be made in their territories for the distribution of collective relief to the internees. They shall likewise facilitate the transfer of funds and other financial measures of a technical or administrative nature taken for the purpose of making such purchases. Article 8. The foregoing provisions shall not constitute an obstacle to the right of internees to receive collective relief before their arrival in a place of internment or in the course of their transfer, nor to the possibility of representatives of the protecting power or of the International Committee of the Red Cross or any other humanitarian organization giving assistance to internees and responsible for forwarding such supplies, ensuring the distribution thereof to the recipients by any other means that they may deem suitable. End of Section 29. Recording by Maria Kasper. End of Geneva Conventions, August 1949.